Yeah, good evening to you all and welcome to the lecture on Law of Sea and Maritime Law. Today we start with week 4, lecture 3. Now, in the previous lectures, we were discussing about exclusive economic zone. What is exclusive economic zone? That is the area within the sea waters determined from baseline onwards, and that area is actually can be extended up to 200 nautical miles. That is the maximum width. To that extent, it can be extended. And further, it's important to understand that it does allow the states to have different kind of rights. So the rights, basically this zone is relevant for classification or different kind of rights that state does have over the sea waters. Primarily the rights are sovereign to the extent of sovereign concept to the territorial waters, and then further the rights they are remain still to the sovereign context, but to a reduced amount in contiguous zone, and further they again get confined only to exclusive economic exploitation when we talk about the exclusive economic zone. And here the other difference is that in case of exclusive economic zone and contiguous zone, the foreign states and the ships belonging to the foreign state also does have the rights, and but those rights are subject to the conditions as set by the coastal states. Rather, we can define or classify that certain rights of the ships belonging to the foreign states, that means not from the coastal states, they might be having some set of rights as the primary rights and some set of the rights as secondary rights in comparison to the rights of the coastal states. So the kind of rights that are secondary in nature, they are subject to the whims and fancies of the coastal states, but otherwise they also does have the primary rights. Whereas when we say the territorial waters, it's all primary rights or the main rights all belonging to the coastal states. That is why we say that there is a kind of sovereign authority up till the territorial waters. And this area, exclusive economic zone, is further relevant for classifying these rights up till the seabed area and subsoil area. Now this is the map. What do we mean by territorial waters? I again repeat this map. Earlier in previous lectures also I have shown. Now this is the baseline area. You can see firstly the yellow shade, that is land area. And then here we can see the stretch of water that has surrounded the baseline area, and this water actually belongs to the sea area. Now here we can say the baseline, this is the baseline up till from this point we draw the baseline, and something that is on the landward side from the baseline, that is considered as internal waters, and something that is on the seaward side of the baseline, that all belongs to the sea waters. So here is the baseline drawn, and after this we have territorial waters, that can be extended maximum up to 12 nautical miles, that is the maximum. Then further there is another 12 nautical miles area across this water body or the sea area, that is contiguous zone. And then after this contiguous zone we have exclusive economic zone. But exclusive economic zone is not seen exclusively, that means it does not minus or it does not devote territorial waters, or it is not excluding this territorial waters or contiguous zone, but including territorial waters, contiguous zone, then it all covers exclusive economic zone. The maximum area that can be extended is up to the 200 nautical miles. Now further, with regard to exclusive economic zone, Article 59, basis for the resolution of conflicts regarding attribution of rights and jurisdiction in exclusive economic zone. In cases where this convention does not attribute rights or jurisdiction to the coastal state or other states within the exclusive economic zone, and a conflict arises between the interest of coastal states or any other state, the conflict should be resolved on the basis of equity and in the light of all the relevant circumstances, taking into account the respective importance of the interest involved to the parties as well as the international community as a whole. Now, when the rights all across the exclusive economic zone were defined, there can be events, there can be situations and interpretations given by the coastal states that are not defined by the UNICLOS or by the set of rights that are acknowledged by the UNICLOS. So in that eventuality, what can be the option? And those rights can be belonging to either the coastal states, those rights can be either belonging to the neighboring states, that is the states that are neighboring the coastal states, Further, they can also be to that of the landlocked states. So that means there can be various kinds of rights in question depending upon their own circumstances. And let's say there are situations when those rights are not defined. So that can be, there can be chances of issues, there can be chances of conflicts. But then the question is how those conflicts can be resolved, whether we take historical perspective, whether we take the political aspect or economic aspect to resolve this confrontation, or let's say the issues that have come up between the parties. So in the light of these situations, the unique clause has in one way or the other tried to cover those situations with an open-ended interpretation given. So it's not that they have added any principle, but they have given optional options that can be adopted, but those options are keeping in mind how the different kind of rights between the different parties they can be realized, or how the balance between the different kind of interests that are questionable within the parties that can be settled. So in the light of this, it states in cases where this convention does not attribute right, that means unique clause is not able to settle the rights in those situations, or jurisdiction of to the coastal states or other states within the exclusive economic zone, and a conflict arises between the interest of coastal state and any other states, that means for the undefined purposes or for the undefined rights the conflict arises, the conflict should be resolved on the basis of equity. That means we take into consideration the higher aspect of justice, we take into account the higher aspect of the morality, where we are above the interest, sole interest of one party or exclusive interest of one nation, rather than we take into consideration the larger interest of humanity. On the basis of equity and in the light of all relevant circumstances, that means based on what circumstances those claims about the rights are made and how that can be resolved, taking into account the respective importance of the interest involved to the parties, therefore also the kind of interests that are being claimed here by different set of groups, as well as the international community as a whole. So it's not only confined to the rights of the state, but what can be better for the international community as a whole. And secondly, why they have taken into account the international community as a whole, because the examples that are set by those interpretations, those examples will be referred in future. So in the higher sense of morality, those interpretations should be done so that in future, if there such like circumstances arises, then in the larger interest of community or international community, the interpretation can be made likewise. Next is regarding artificial islands. So these are like something newly added here, because a long time back there was no such concept of artificial island being installed or added here at the exclusive economic zone area. But now there is a concept of artificial island. One important question that arises regard to artificial island, whether they can be compared with the natural islands, and if they can be compared with the natural islands, that means they should have the equal extent of rights. But artificial islands are not given the similar acknowledgement in the international law as the natural islands does have. And secondly, if the artificial islands, they are being given the recognition of equivalent nature or of similar nature than that of the natural islands, then any powerful country may keep on extending their artificial island, they may keep on adding artificial islands, and that can be security threat to the other nations, and that can also be a threat for the exploration and exploitation of the resources of that powerful nation. So that is why the rights are defined, and the extent of rights are differentiated and defined between artificial island and the natural islands. So Article 60 states artificial island installation and structure in exclusive economic zone. In the exclusive economic zone, the coastal state shall have the exclusive right to construct and to authorize and regulate the construction, operation and use of artificial island. That means here this is the area, exclusive economic zone, where the coastal state does have the exclusive right. Means it's not the rights of other neighboring country, like I can draw it here, what it means by the exclusive right. Let's say this is the Indian coast, and this is territorial water, this is contiguous zone, and this is exclusive economic zone. And let's say this is another country here, Bangladesh and all. Now this is the exclusive economic zone. That means here India does have the right to have those artificial islands if they intend to do so. But let's say there it borders here Myanmar, and the exclusive economic zone or of the Myanmar extends up till this point. So this is like high sea area. So Myanmar can have the artificial island over this place, but it cannot be extended to this high sea area. So that is the point here. So installation of the exclusive economic zone, the coastal state shall have exclusive right to construct and to authorize and regulate the construction, operation and use of artificial island. So they have different kind of rights that are of the right to construct. Then they do have the right to authorize its use and to regulate the construction, operation and use of artificial island. Secondly, installation and structure for the purpose provided for in Article 56 and other economic purposes. Further, these coastal states does have the right to set other installation, like India has set its installation at the Bombay High to explore natural gas and oil. So different kind of installations can be done, different kind of structures can be laid down that are for the purposes provided in Article 56 and other economic purposes. Third one is installation and structure which may interfere with the exercise of the rights of the coastal states in the zone. Installation and structure which may interfere with the exercise of the rights of the coastal state in the zone. They are all like included here. Now the example of one artificial island, that is, you can see Palm Jumeirah is one such artificial island in the Gulf country, and it's very famous. So all you can see the main, it is the extension of the main part, and they have created, this is the shape of the tree, palm tree. So that is why it is named as Palm Jumeirah. Now after this, we have broadly covered the law of sea. Now let's take the discussion towards the Indian side, that what are the Indian laws with regard to the sea and maritime law? Are there any specific laws in the country that are to achieve the objectives that are set by UNICLOS? And how they have divided different areas within the international law, or let's say the areas more specifically in relation to the law of sea, the specific acts, they have divided different zones and areas with regard to the law of sea. So let's give a look to this. The prime importance of marine dimension of existing developmental policies by the government of India is relatively new. So the Indian law that has emerged, actually it started during the British time, but independent laws, they came into emergence after the British people had left. And after realizing the set of rights that are given through UNICLOS, or let's say that are acknowledged by the UNICLOS, the Indian legal system has devised and also enacted several laws that are keeping in mind the objectives that are set by UNICLOS, firstly. Secondly, those laws are also keeping in mind the Indian neighbors, like we have Bangladesh, where we have porous borders, where we have very rugged terrains, the border with rugged terrains. Or let's say there the borders are with stormy sea areas, so different kind of laws are acting where the rights of the Indian state, rights of the Indian coastal region, rights of the Indian fisheries and marine resources, as well as the marine route that are not simply acknowledged, but they are also protected. So there are different set of laws, we'll come to that. The major issue which need elaborate evaluation before concluding any national legal regime are, firstly, current status and future prospect of related public policy in the light of international obligations and responsibilities, which UNICLOS 3 bestows on the coastal nation like India. So Indian laws are consistent with, they are like aligned with what the UNICLOS has set the objectives, the major provisions that are included in the UNICLOS. So the Indian laws are in compliance to that or aligned to that. An analysis of the Indian effort in support, emergence and promotion of a stable and balanced regime of law for world's oceans and practice of states and different bilateral and multilateral agreements. So India, realizing the fact that it has a big coastline and many aspects or many features of the Indian trade, they are through the sea route, and also for maintaining the good global relation with other countries. India has put effort in support, emergence and promotion of stable and balance, not like that India has shown its aggressive policy, or it has shown its tendency to have more and more resources from the sea, but keeping in mind that how the balance can be maintained between different neighbors, despite the fact that their coastline might be more complex, and it would not be so convenient for India to draw the border, the territorial borders through the water body. between these neighbors, but still India has tried to maintain the balance. For example, the Indian borders that are bound by the Indian borders that are drawn along Sri Lanka, Bangladesh, through this territorial water area and the other seawater area. So that itself shows the intention and the efforts that are made by India to maintain some balance. So, an analysis of Indian efforts in support, emergence, and promotion of a stable and balanced regime of law for the world's ocean, the practice of the states, and different bilateral, multilateral agreements. So, this is also based on the natural law principles that the resources of the sea should be used by all. Basically, they are not the resources of one individual nation or one nation exclusively, but they are the resources belonging to the human beings all. Therefore, we should not be very rigid with regard to the boundary distribution or with regard to the rights distribution through the water bodies. So, in the light of that, these acts are drawn in India. Issues in conflict regarding use of traditional method of resource production and consumption in contrast with the modern technological adaptation. Now, since the kind of Indian population we know, it's a wide variety of populations. Some of the population, they are very much capable and they have the economic potential to use the modern technology to the great extent. But then there are a large group of people in India, those who find difficult to upgrade their skills and also upgrade the technological resources. So they still go by the conventional methods or the conventional resources for exploration to the sea areas. For example, the fishermen go for the catch of the fishes to the coastal waters and even beyond, like towards Sri Lanka, towards this Arabian Ocean. So they may not be having very well equipped boats, or they may not be having very technologically sophisticated devices that can be very supportive or that can be safeguard to their life. So that is one aspect. And then there are Indian companies, those who can afford to have most upgraded level of ships for the transportation of goods from one country to another through the sea route. So that is a big contrast we see in the same country. So in the light of that, we have to draw the laws. That means the scope of the Indian laws should be so broad and so wide that they can cover the traditional methods of doing traditional methods of applying the skills, or traditional methods of doing the business, or traditional method of exploring and exploiting the resources of the sea, both living and non-living, as well as the most modern methods, because then we have to take into consideration different set of rights, different parameters to define the rights, and also in case the state need to give the protection, then that will also be of different type. So issues in conflict regarding use of traditional methods of resource production and consumption in contrast with the modern technological adaptation. Settlement of the national exclusive economic zone and continental shelf disputes would do much to foster amicable relation among the neighboring coastal countries. In that respect, India has shown wisdom that they even have sacrificed their own continental shelf area to a certain extent, and the territorial waters area when we see the case of Bangladesh, and to an extent with the Sri Lanka also, so as to settle the things amicably. Likewise, agreements on transnational marine resources and activities would provide profound opportunities for further cooperation. As far as the regulatory framework is concerned, important shortcomings remain between handling marine and coastal problems, which can best be addressed by a unified legislative approach and a corresponding nodal administrative machinery. Despite the fact that Indian system has developed several laws with different set of objectives to cover different kind of challenges we see in the coastline or the sea waters, still there remains many coastal challenges, many coastal problems that need to be addressed through better law, and not simply by the better law, but the execution of the law through the administrative machinery. So there either it will take more time, or we need to be more advanced in our technology and having more dedicated people. So as far as the regulatory framework is concerned, important shortcomings remain between handling marine and coastal problems. These problems do remain, like whether we do have the proper infrastructure to know about the sea storms, or what safeguard measures can be taken to protect our ship and the port facilities during the sea storm, or if there is a oil spill near to the coastal region, then whether we are equipped to handle those emergent situation, or if the ship near the coast or even far from the coast is in danger, or they require some serious repairment. So whether we are equipped, or we do have something of that nature, or something of ancillary nature that can be supportive to the ailing ship. So that kind of thing very much depend upon the advancement of technology. Plus the law. As far as the regulatory framework is concerned, important shortcomings remains between handling marine and coastal problems, which can best be addressed by a unified legislative approach and corresponding nodal administrative machinery. Now, these were the problems highlighted from the technological perspective, but the other coastal problems are like the pollution, the waste disposal, the oil spill, or the growing hazardous waste all across the coastal area, and even the nuclear waste, that is a very big problem. With regard to the hazardous waste, that can be the asbestos, the remnants of the decommissioned ships, or sometimes the ships that are sent by the developed nation without removing the asbestos or other hazardous substances. That can be very health hazardous to the workers that are there at the port facilities. So all that need to be settled through different set of laws, not simply different set of laws, but the nodal agencies that are working to execute those laws, they should be quite capable and committed to resolve these crises. Maladjustment between the regulatory framework and overall requirement of the existing situation prevail. That means many things, they are still not totally within the reach and totally within the control. That will be definitely time taking, and we learn things by experience also. Beside examining how Indians have traditionally utilized the ocean space and their knowledge about ocean resources and issues, the implications for inducing a high level of public awareness regarding rights and duties towards ocean resources need to be explored. Now, so far as the ancient literature is concerned, or the historical perspective is concerned, much has been written with regard to our knowledge for the sea, about the sea, and the pathways that were drawn for exploring different islands and different places through the sea route. But that is again confined within certain kingdoms and only with certain period of time. So much can be found ancient literature and the historical books, but that could not be translated into modernity. That means when we compare it with the present day situation and the traditional knowledge we had about the sea route and the resources, we find a big gap, that there is no such direct translation or transformation of such knowledge to the present generation, and neither we do have done such research through which we can maintain that continuity. So there is a lack of continuity, then there is a lack of consistency as well. But definitely it is not deniable. There are great aspects of fact which shows that there has been Indian movement of the Indian kings for the trade purposes, for expansion, expansion of the territories through the sea route. So like that, if you go to the southern part of the India, there are ample evidences that shows our keenness to know about the sea route and also the technology we had at that time. Besides examining how Indians have traditionally utilized the ocean space and their knowledge about ocean resources and issues, the implications for inducing a higher level of public awareness regarding rights and duties towards ocean resources need to be explored. So what presently we need to do, realizing the challenges we are facing, that people should be made aware about the rights and duties towards the sea resources and how the resources of the sea can be used in the best possible interest of humanity. So that has to be widely discussed and educated. The people need to be educated in this regard so that they do have the constructive thinking about the use of the resources, realizing the fact that India has a very big coastline in comparison to the other neighboring states, and the use of it will very much depend upon the potential the people does have. Regarding deep sea mining, it was on 17th August in 1987 that India became the first registered Pioneer Investor and award by ISA, International Seabed Authority, and a mining area of 150,000 square kilometer was allotted for preparing a complete work plan for exploration and exploitation of polymetallic modules in the Central Indian Ocean. That is one such example of our outreach towards the use of sea and also finding out the minerals and precious metals to the far off area in the sea. India used the term territorial waters while extending its sovereignty to a belt of sea adjacent to its coast in its national legislation. So, we have accepted and acknowledged firmly the concept of territorial waters to the extent our sovereign law or our laws are applicable. So, it's like part of our constitutional agenda that we need to recognize the territorial waters and we need to protect also the territorial waters. Now, the first president of India, they marked his words in concern to the territorial waters and our rights towards the sea. This read, I, Rajendra Prasad, President of India in the 7th year of the Republic, do hereby proclaim that notwithstanding any rule of law or practice to the contrary which may have been observed in the past in relation to India, or any part thereof, the territorial waters of the India extend into the sea to a distance of 6 nautical miles measured from appropriate baseline. So at that time, since the UNICLOS 3 has not framed the new definition about the territorial waters. As the UNICLOS 3, it came later on. It was in the year 1982 that the UNICLOS 3 was established, and finally it defined the rights of the different parties in a new framework. But depending upon the earlier framework, so we had the territorial waters that was acknowledged by the India and also pronounced by the first president that extended up till 6 nautical miles. It also adopted 12 nautical miles contiguous zone for the purpose of customs and sanitary regulations in December 1956. Presidential Proclamation, United Nations document A/conf.1915. Now, one thing I would like to add, why the ascertainment of this territorial waters and contiguous zone by the state is necessary, because based on that the maps are drawn, and after a nation has drawn the maps, making the claims to that extent, that are sent to the United Nations, and United Nations, after testifying it will confirm that this is the extent of the state's right towards the territorial waters area, towards the contiguous zone area. The 1976 Maritime Zone Act further clarified that India accepted the limit of 24 miles in a spirit of compromise as provided for the same limit. Later on, the Act maintained that the Government of India would exercise such powers and take such measure in or in relation to contiguous zone as it might consider necessary with regard to security of India and immigration, sanitation, customs and other physical matters. So up till 12 nautical miles, we had the sovereign rights. Beyond this 12 nautical mile, that is the contiguous zone, we had sovereign rights, or we do have sovereign rights, but they are not in all the areas. Like in case of the territorial waters, we have sovereign rights over all the areas. That includes even the airspace area. That means no aircraft can fly above the territorial waters without seeking the permission from the Indian government. Whereas in the contiguous zone, they can. But here we do have the security concerns with regard to the waterways, that is the immigration check, sanitation. That sanitation here means the no eatables, no goods can be imported or introduced in the Indian markets or Indian ports without confirming that they maintain the health standards or the required medical standards, or let's say required standards to fulfill that they are not health hazards. For example, like if India has, let's say, imported any meat product that is coming from far off places, but India finds, or India comes to know that that meat product is from the infected meat, or that country was having some kind of flu infection to those birds whose meat is exported. So India will not allow that to enter beyond its contiguous zone. So the contiguous zone will be the checkpoint where they will firstly check whether that is meeting the health standards or not, and if it does not meet the health standard, then it will be returned. So that is what it means by sanitation. Customs, the custom duty, that what kind of goods are entering India, what is the right kind of duty that can be imposed, and other related physical matters. So with this, I thank you very much for being part of this discussion. We continue further with the lectures on law of sea and maritime law soon, and we discuss further on law of sea soon. Thank you very much for participating in this lecture series. Thank you.